I'm going to go over some comments, hopefully fairly quickly. One of the comments is calling someone stupid as opposed to uninformed or misinformed is very personal. No, it's not. If someone is uninformed or misinformed, then they're uninformed or misinformed. If they choose to be uninformed or misinformed, then they are acting stupid. Now, if I call someone stupid, what I mean to say, like if I've called James stupid, my intention in doing that is to say that his actions are stupid. James is obviously not a stupid guy, but what he's doing is stupid. So there you go. And if you're more worried about the word choice rather than the message behind it, then you're being petty. And maybe you should think about that. Why are you being petty? Why do you care that I called him stupid rather than misinformed when he was acting stupid and choosing to be misinformed? He asked me to email him. No disrespect, James. I am not going to email you, and I'll tell you why. It's not because I dislike you or anything like that. It's but because I think ethically I'd be in violation if I presented myself to you as being available for legal advice. I am not competent to give legal advice for Texas. I am not a member of the Texas bar. You need a competent Texas defense attorney. So that is the only legal advice I will give you. I can give legal analysis about Texas cases, but I cannot give you legal advice. I would be in violation of my ethics if I did so, and I may be subject to sanctions. So I do apologize. I cannot, I will not, but I do wish you the best of luck. He says, thank you for your analysis. You definitely know a lot more about blah, 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 yada, yada. A couple things I can tell you is I don't remember much from what happened 3 years ago. You shouldn't have to. Your lawyer should look into everything, and your lawyer should at least make the prosecution prove every element of the crime. You don't have to know anything. You don't have to say anything. You could just sit there and look pretty. It is up to the prosecution to prove that you committed all the elements of that crime. And it's your lawyer's job to find any exculpatory evidence or to point out any flaws in the way the evidence was presented by the prosecution, and to craft an argument that may sway the jury to believe, to look at the evidence in a light more favorable to you. So those are the roles of the lawyer. You should probably just sit there and smile and try to make yourself look less threatening. That's what I would recommend to you. Not as legal advice. Obviously, if your lawyer asks you to do something different, then follow the advice of your lawyer. But I do believe I was told if I didn't comply and sign papers, I would not be released from the cage. That is most likely correct. They do require some surety that you will return for your trial. And if you're claiming to be an indigent, there is no likelihood that you will return. There's nothing tying you to that county, let alone the state. And so I think a bond is typically a good call for someone who is indigent. Now, if you owned a home and had a family and your kids were in school and you had a job and all that other fun stuff, then maybe a bond would be less required. But because they did make the determination there was a required bond, then yes, your choice was to either sign the paperwork and get the bond and promise to return to court, or stay in jail waiting trial. You do have I believe, a constitutional right to bond if at all possible, because that would allow you to get an attorney and prepare your defense. Can I make voluntary decisions under threat? Yes, you can. You're confusing some contract law where, like, if someone is threatening physical violence against you, if you're signing a contract under duress, if they're threatening you or your family, like if they have a gun to your daughter's head and you sign the contract, you can void the contract. Actually, yeah, you can void. It would be voidable at that point. However, in this case, you weren't facing threat of violence. You were facing threat of not being released. That's not violence. You had a choice. You could either sign the paperwork, get the bond, and go free, or you could sit in jail. Just like when you go up to the gate at Disneyland, you have a choice. You could pay the people at Disneyland, go in and ride the rides, or you cannot pay them and stay outside. There's no threat of violence. However, if you break into Disneyland, then they can use violence in removing you from it. But they're not making you do anything under threat. Okay, so he says, I thought I was presumed innocent. You are presumed innocent. The judge will presume you're innocent, and the jury will presume you're innocent. The prosecutor will presume you're guilty, and he will make every argument in an attempt to show you're guilty that he can make. And he will paint the facts in a light that make you appear to be guilty. Whether you are or not, I don't know. But the state is presuming you are guilty. That is why they are bringing trial. If he thought you were innocent, remember those cases that you cited that said that it had to be a truly contested decision. If the prosecutor doesn't think that you're guilty, then there's not an actual disagreement, and I think actually technically he'd be probably violating some ethics rules if he brought a case where he thought you were innocent. Why would I be caged until I prove my innocence? You wouldn't be caged till you prove your innocence. You'd be caged until you were found not guilty, or until you served your time, or obey their threats to fill out paperwork. It's not a threat to fill out paperwork. And this language that you're choosing to use is you're really trying to paint yourself as a victim, and I think you should stop doing that. The courts, everybody they hear believes they're a victim. And people's empathy for victims tends to dry up after a very short period of time when everybody they deal with is a victim. Everybody's a victim. And then they go through the trial and it turns out they're not a victim at all. And, you know, people callous up pretty quick to stuff like this. And remember, you think every interaction you have with a government employee is under what? Threat, duress, and coercion? It's lost its sting. It's there is no sting to that word anymore, James. It's overused, it's played out. I'm not suggesting you find a different one. I'm suggesting that you drop that victim mentality and you let your lawyer do the work for you. I know, that's just the way it works. The attorney was competent counsel appointed by the court 3 years ago. You did not hire him. Yeah, I know that. We saw the paperwork. You did request him, so that is there. I also have never heard from him ever and wasn't even aware I was appointed attorney until a couple of weeks ago when I received a threat to appear. Well, that's interesting. You weren't aware that you were appointed him. It's going to be in the old bond packet. Election of counsel. All right, this was given to you at some point in time. This is instructions relating to preliminary initial appearance. And there's your attorney on it. So this was sent to you 6/4/15, 8/51/47, or somewhere thereabouts. So, and here's where you requested him. So I'm going to go with, what in the hell, Bobby? I wonder what anybody saw in here. Brandon Cass, yeah. Uh-huh. Huh. Well, if you saw any porn, I swear to God it wasn't me. Somebody else put it on there. Anyway, sorry. And his name was listed as my attorney. Yeah. So if you haven't heard from him, you do need to contact him. I believe in this piece of paper. There is your attorney, David Woodruff. There's his phone number. There's his alternate phone number, Attorney Woodruff at AOL.com, Farmers Branch, Texas. That's his address. If you haven't heard from him, you should really notify the court. Like at that first hearing, instead of making all the problems, you should have said to the court that you didn't have an attorney because you can't get a hold of your court-appointed attorney. He's still bar number, but if you can find him, maybe 3 years ago, he could have requested a speedy trial for me if he was in any way competent. Obviously, he could have asked for one, but he probably wouldn't. The speedy trial thing, yes, you are entitled to a speedy trial, but speedy is kind of in quotes. There's no bright line rule. There's no real definition of when your right to a speedy trial has been violated. There's been some really long durations between arrest, indictment, etc., and the actual trial that have been found to not be violating the speedy trial thing. I think the biggest factor that you have to look at is whether or not your case has been prejudiced by the delay, like if witnesses have died or moved or are no longer available, if evidence has deteriorated or degraded, like DNA evidence or whatever, it's degraded and you no longer have access to it. If the police storage, their crime or evidence storage is burned down or something and you no longer have access to the evidence, things like that, where it's prejudiced your case, then that's really where the speedy trial thing comes into play. It's not, there's no bright line rule. And you're like, oh, it was too long. Well, maybe. Great overall analysis, very honest to the point, but one hang up I have is around 11945. 11945 is, it's this one. It was where I was saying that the judge presumes the statutes to be correct. You claimed that something in law is assumed. I said it was presumed. The statutes are presumed to be correct. There is a presumption that the statute is a valid law because it's been passed by the House and signed by the governor. So there's a presumption that that is a valid statute. If you want to challenge that statute, you can. That would be part of your defense. You talk to your lawyer about it. I wouldn't recommend it on your own. But you could challenge a statute for violating or for being in violation of some other statute, like if there's a conflict between two statutes, or if there's a conflict between statute and the state constitution or a federal constitution, or if there's a conflict between the state statute and a federal statute. There are various ways that you can go about challenging a statute, but good luck. So when I'm saying that the judge presumes the statute to be correct, the state has presented her with the statute that they claim you violated, and they've presented her with the indictment saying that a grand jury thought that you violated that statute. And she's going to presume that the grand jury indictment is true and correct, that they actually did find probable cause, because there's a judicial hearing that did that. A grand jury is a judicial hearing. And she's going to assume that the findings of that were correct, that there was probable cause. That doesn't mean you're guilty, but that means that they found probable cause. She's going to assume that the statute is a valid statute, because that's what judges do. That's their job. There are other things that she may take judicial notice of, like she may take judicial notice that the court building that you're in is located in Dallas County. If that comes into play, the court is aware that the Dallas County courtroom is in Dallas County. The prosecution wouldn't have to prove that. The judge would be like, yeah, we're here in Dallas County. There's no proof necessary. So yeah, there are things in law that, in the practice of law, that are assumed. It's called taking judicial notice, and isn't law based on facts? Yes. So you apply the facts to the law. So here's a statute, and here's your fact pattern, and the prosecution is going to say that this fact pattern is in violation of this statute. He's going to paint the facts in such a way that it looks like you committed the crime. And your defense attorney is going to lay out the same fact pattern, but he's going to highlight different facts. And he's going to say, if we look at the facts this way, it looks like you didn't violate the statute. So it's very fact-based. Every case is different. Every case has different facts. And so you definitely have to go through the facts. So it is based on facts, but the statute is going to be presumed correct unless your attorney challenges it. And that's probably not going to be a winning case. If you're basing something on assumption that can't be logically or factually explained, it can be logically and factually explained. The legislature wrote a bill. The governor signed it into law. It went into effect. I think that law went into effect in like 2012. So it's been valid law on the books for what, 6 years now? 3 years at the time you allegedly violated it. It's logically and factually explained. They have the evidence because it's located on the government website. It is in the it's in the statutes that are published by the and the bills that are published by the legislature. It is in the Westlaw or LexisNexis or Deering or whoever, the code books, the people who print them out and put them in law libraries. It's in all those places. I'm sure you're not the first person who's been charged with violating that statute. So other courts are going to have heard cases on that statute. It's a known fact. It is. That's why the judge can just say, yeah, I'm taking judicial notice of it because it is in the the state registry of statutes, whatever that is. It's on the state website, the official state website. It's published, etc. It is logically and factually explained. And no, it's not a logical fallacy. You don't understand what a logical fallacy is. You did point out somewhere in the video how and why politicians' scribbles apply. I think he means statutes. You stress quite a bit while laughing about how many of them, I believe he means police, there are, and the amount of firepower they have. Yes. Yes, politics is based on power. The state has power. And the reason why the state has power is because of people with guns. State laws apply because people with guns enforce them. If people with guns did not enforce state laws, then the state law would be meaningless. One of the cases that we went over that went up to the Supreme Court was where people in, I think, the Commonwealth of Massachusetts were suing to get a judicial statement that some contraception law in Massachusetts was unconstitutional or something like that, but the state wasn't enforcing the law, right? And so the court said, well, there's no reason to hear this because it's not actually being contested. There aren't people on both sides of the issue arguing it. The state doesn't care. The state's not enforcing the law. So now imagine that, but where the state wasn't enforcing any law. There were no men with guns who were enforcing the state law. Then essentially for all intents and purposes, there would be no laws. I mean, you'd have men in suits in a funny building that were signing pieces of paper, but if nobody's enforcing them, then they're just pieces of paper. They're just the scribblings of madmen. But once society agrees on a set of laws, and society puts men with guns from society stand up to defend and protect those laws, then all of a sudden those laws have power because of the men with guns. And it is absolutely, if the citizens all rose up, that's why the Second Amendment is a very important amendment, is because if one day the government, whatever form of government it is, city, state, or local, city, state, or federal, if the government puts into place a law that the citizenry finds abhorrent, then the citizenry will rise up with their guns and take back that power from the government. And they will institute a new government with new laws, and men with guns will protect those laws. And you are in a minority, James. You are somebody who thinks that people should just be allowed to do whatever they want and abide by their own moral code. The problem with that is that there are people with really bad moral codes. There are people with moral codes that allow them to rape and steal and kill and maim and have sex with kids and do all sorts of other nasty, terrible stuff that society as a whole finds abhorrent. That's why your system doesn't work as a form of government, and it never has worked, and it never will work. And everywhere you go, in any place where there's two or more people are gathered, there a hierarchy forms. You go to the tribes in like New Guinea or Africa or whatever, they will have like a chief or a council of elders who make the rules, who enforce the rules. That's just the way humans are. We are a social creature, and we automatically form hierarchies. That's nature. That's a perfectly reasonable answer to me on how these statutes apply, and I'm perfectly aware you'll be caged based on that jurisdiction. Well, that's good. So stop arguing it, because it's a useless, frivolous argument. So can we at least admit that the biggest gun is what grants jurisdiction and authority and makes anything a politician writes on paper law? Well, yes, sort of. You're kind of misstating it, but yeah, it is the biggest gun that determines who has the power to make or break the rules, or to make or unmake the rules, I should say. It's not just what a politician writes on paper. In your civics class, you may have realized that there are lots of steps that go into turning a piece of legislation into law. So be aware of that. You know, typically there's a lower house and an upper house, and they may call them different things in different states, but typically both houses will have to agree on the piece of legislation, and then it'll have to go up to the governor, and the governor will have to sign it, and then if somebody challenges it, then a court will have to look at it. There are steps in place. There's a reason why our system is the way it is, to provide the checks and balances. It's not just something a politician writes on paper that's automatically turned into law. You're trying to minimize it. It's a complex system that obviously isn't perfect, but it is currently the best system that we found. So after that, we can move on, and I won't disagree with you on much. Well, that's good. I'm glad we don't disagree on much. He said videos are not allowed on floors with courts. I said I wasn't aware there was a court on that floor. No one said anything about not knowing there were courts in the building. Okay, that's fine. And I think we are good. All right. So thank you for watching. Mr. Freeman, again, best of luck. Again, no, I won't email you, but it's because I don't believe ethically I can. You do need to find a lawyer. If you need to, try getting a hold of someone at the court, like the court clerk, and ask them politely what the process would be if you can't get a hold of your court-appointed attorney. I don't know the process for that. I've never not responded to a client, but I'm also not a public defender. So, but yeah, so be nice, play nice. Don't make enemies out of people that you don't need enemies of in that courtroom. But call the court, see if there's something that they can do to either get the attorney to respond to you, because he is obligated ethically and legally. He's obligated to respond to you. I believe he could be facing sanctions if he doesn't. So talk to someone at the court, see if they can't get you in touch with him or have him get in touch with you. And if not, at least they're on notice that there's a problem. In the meantime, maybe you do want to go seek out competent counsel that isn't somebody who's going to be flaky on you. It will be expensive, but you know, how much is 10 years of your life worth? Thanks for watching. Have a great day.